Okay guys, next we continue with the duties of agent and principal. Sorry. So this is very important subtopic. Duties of agent may be divided into 10 main duties, and duties of principal 3 duties and 3 main duties of principal. Okay, with regard to the duties of agent to his principal, normally the duties of agent is clearly highlighted in the agency contract between them. Okay, however, let's say the agency contract is silent in regards to this matter, so the duties are governed by um, section 164 until section 178 of the Contracts Act. Okay. Okay, next. Okay, first duty of agent is duty to obey the principal instruction. In other words, duty to follow the principal's instruction. So based on section 164 of the Contracts Act 1950, it provides that an agent is bound to conduct business of his principal according to the directions given by the principal. So based on the direction given by the principal. When the agent act otherwise, if any loss be sustained, he must make it goods to his principal. Must make it goods here means that agent must compensate, okay, or pay compensation to his principal. And if any profit accrues, he must account to it. Okay, so fail to obey this instruction lead to the breach of contract of agency. Okay, as you can see, there is a case, Turpin against Bilton. In this case, agent has been instructed by the principal to insure his vessel. However, the agent failed to do so and the vessel was lost, and as a result, the principal sustained losses. So in this case, the agent is liable for breach of duty and thus he must pay compensation for the loss. Okay, however, whether agent must follow unlawful instruction given by the principal? No. Okay, so there is no duty to obey unlawful instruction as decided in a case of Cohen against Kittel. Right. Next, we continue with the next duty of the agent is to act according to customs if there is no instruction given. Okay, we are using the same provision, okay, under section 164. An agent is bound to conduct in the absence of any such directions or instructions according to the custom which prevails in doing business. So depends on the types of business. Okay, if the agent acts otherwise, in other words, if the agent fails to act according to the custom, if any loss be sustained, then he is liable to pay compensation to his principal. Okay, example here is, let's say A is an agent that engaged in carrying on B, a business which it is the custom to invest from time to time. So custom is to invest from time to time and interest the monies which may be in hand or needs to make the investment. So if the agent have money, okay, but he failed to invest for the purpose of his principal's business, then A is liable to pay compensation to B, the interest usually obtained by such investment. Okay, so even there is no instruction given by B, but A must act according to the custom of their business to invest from time to time. Okay, next duty under section 165. Agent must exercise care and diligence in carrying out his work and to use such skill as he possesses. Okay, in what situation agent must exercise due care and diligence. This is where agent must exercise this skill, okay, must exercise care and diligence in order to avoid principal from suffer loss or damage. Okay, in other words, to avoid from any neglect. Okay, one of skill here means the lack of skill or misconduct. So in what situation agent must act according to section 165? Okay, if an agent is appointed to sell goods, it is his duty to obtain the best price as possible. Okay, if the agent receive a better offer upon obtaining the first offer, which was conditionally accepted, he must inform this to the principal. So if agent receive better offer from other party, he must inform it to the principal. Otherwise, he is liable for breach of duty. If the agent is being employed for professional service, he must use all his skills and expertise as the other professional man would act. Okay, so there are three situations that require agent to act, to exercise due care and diligence. Okay, example of case. This is quite a popular case for section 165, Keppel against Wheeler. In this case, the defendant agent was employed by the plaintiff as his agent to sell the plaintiff house. An offer from the first offer, so please take a look. We have the first offer was received and accepted by the plaintiff, but it is subject to contract, meaning that it was conditionally accepted. A few days later, a higher offer, meaning the second offer for the same property, was made by X, the second offer, the second party, but this offer was not communicated to the plaintiff. But the defendant here, the agent here was, the agent failed to communicate about the higher offer to the plaintiff. Okay, so since the plaintiff did not know about the higher offer, he signed a contract with the first party tadi. Okay, so in this case, the defendant was liable to the plaintiff for the difference between the two offers. Okay, only liable for the difference between two offers, and this is based on the inference that the agent must disclose everything coming to his knowledge which is likely to influence the principal or making the contract. Okay, for example, let's say the offer from the first party is 500,000 ringgit. Okay, but failed to communicate to the plaintiff about the second offer. Let's say the second offer is the higher offer compared to the first offer, 600,000 ringgit. So there is a difference of 100,000 ringgit here. Then agent is liable to pay the difference to the plaintiff or to the principal. Okay, next, under section 166, agent is liable to render proper accounts when required by the principal. This is including money received by him from illegal and void transactions, provided that the agency contract itself is not illegal. Example of case, you may refer to the case of Real against Kennedy. Okay, if the agent has been entrusted with the principal's money or property, he is bound to keep the money or property separately from his own property. So, he cannot mix up, okay, his own property with the principal's property. So, you tak boleh combine dalam satu account lah, okay. And then under section 171, agent has duty to pay to his principal all sum received on his behalf. Okay, so anything received from the third party must be paid to the principal. However, there is an exception where agent may retain or deduct out of some money received on behalf of the principal on the following matters. Based on section 170, agent may retain or deduct the money received on behalf of his principal if he already made an advance or expenses incurred by him in carrying out his duty. For example, the principal borrow the agent's money as advance. So when he receive money from the third party, so dia boleh deduct the advance. And then his commissions or other remuneration payable to him acting as agent. So under these three circumstances, agent may keep or agent may retain and deduct out of some money received on behalf of his principal. Okay, so under section 174, agent only has right to retain the principal's property in his possession, but he has no right to sell the goods without consent of the principal. Okay, next, duty to communicate with the principal. This is linked with section 142 just now, appointment by necessity. So during emergency period or difficulty, agent must use all reasonable diligence to communicate with the principal in order to seek for instructions, as stated under section 167. Okay, however, agent may use his own discretion if the communication is impossible or communication is impracticable or any delay may cause loss to principal. But you have to take note that agent must prove that he had take so much efforts to contact with the principal. Okay, next, under section 168, agent must act in good faith and not to let his own interests conflict with his duty. In other words, agent must try to avoid conflict of interest. This is based on section 168. Okay, if agent deals with his own account in the business of the agency without obtaining consent of the principal, so without consent, principal may repudiate the transaction. Repudiate here means that principal may terminate the transaction when it comes to the knowledge of the principal about that matter. Okay, so in what situation agent must act in good faith and no conflict of interest? First, agent cannot become a party to the transaction with the principal unless with the consent given by the principal. For example, let's say principal want to buy a house. So agent cannot sell his own house to his principal unless there is a consent given by the principal. So similarly, it happened when agent who is employed to buy shares cannot sell his own shares to the principal without the prior consent by the principal. But if the principal give consent, then he may proceed. No breach of duty. Example of case in Armstrong against Jackson. Okay, agent had been ordered to buy share for his principal, and the agent sold his own shares to the principal without informing the principal in advance, meaning that without consent of the principal. So agent has not acted in good faith, and therefore principal could rescind the contract. In other words, principal can repudiate the transaction. Okay, another example where there is a conflict of interest arise. In this case, Wong Mun Wai against Wong Tam Fat and another. In this case, okay, the agent failed to inform the principal that he had sold it to the second defendant who was his wife. So he sold the land, the half share of the land below the market value, and he failed to inform that he had sold it to the second defendant who was his wife, meaning that ada conflict of interest. So that is a breach of duty by the agent. Okay, under second situation, agent cannot act for both parties. Okay, both parties here means that agent cannot act for principal, and at the same time he cannot act for the third party. In the case of Falwood against Hurley, agent had acted on behalf of both parties, which are for the principal and the third party, by claiming commission from them without their knowledge and consent. So agent has breached his duty towards the principal for not acting in good faith. Another situation that require agent to act in good faith, agent must disclose everything that he knows to the principal relating to all materials of the contract. When he enter into contract with the third party on behalf of his principal, he must disclose everything to his principal. And all money and profit should be put into the principal accounts. Okay, so must have separate accounts. Okay, so that cannot mix up his own money and principal's money. Okay, and next, this is very important as well. Okay, agent cannot make any secret profit out of the performance of his duty. What is mean by secret profit? Secret profit is a bribe, rasuah. Okay, because this mean a secret commission received by the agent without knowledge of the principal. So based on section 168, if the principal knows about the secret profit and consent to it, then agent may keep it. So it is no longer called as secret profit. But the problem here is when the principal knows about the secret profit but does not consent. Take note, but the principal does not consent. So the principal may seek the following remedies. Okay, let's say katalah ada problematic question ask you regarding this duty. Okay, you need to advise the principal to exercise these remedies. Okay, first the principal may repudiate the contract which was made by the agent with the third party as stated under section 169. So the first remedy is principal may repudiate the contract with the third party. Second, the principal may recover the amount of bribe from the agent. Okay, the same provision. This is including where an agent sells at a price higher than was set up by the principal and the secret profit based on by the agent to another person. Okay, example of case, you may refer to the case of Tian Kiong Hua against Andrew S.H. Chong. In this case, the plaintiff bought a flat from a company of which the defendant was the managing director. In this case, agent is the managing director, okay, but he sold the flat to his own principal. Then the plaintiff later authorized the defendant as his agent to sell the flat for $45,000. Okay, and the defendant sold the flat for $54,000 and the difference of $9,000 was credited to the company. So dia simpan, dia masukkan dalam company dia sendirilah. Okay. And later, the plaintiff was entitled to recover $9,000 from the defendant as the defendant breached his duty as an agent. Okay, another remedy available to the principal is the principal may refuse to pay agents commissions or other remuneration. If he already paid commission to his agent, principal is entitled to claim it back. This is based on the case of Andrews against Ramsey and Co. In this case, the principal instructed the defendant to sell property and agreed to pay the defendant £50 as commissions. And then when the defendant received £100 from purchaser, he gave £50 to the plaintiff, the principal, and then he kept another £50 as his commission. And later, the plaintiff found out that the defendant had also received £20. So £20 here considered as secret profit. So later, plaintiff, principal, he may claim both amounts, secret profit and the commission that already taken by the agent. Okay, next remedy, principal may dismiss the agent for breach of duty. And then principal may sue both parties, agent and the third party giving the bribes. Okay, for damages for any loss he may have sustained through entering into the contract. And last but not least, principal may also bring the case under criminal law alleging guilty of bribery under Section 4 of the Prevention of Corruption Act 1961. So also can take action under criminal law. Okay, and apart from that duties, agent also has duty not to disclose any confidential information belong to his principal. Agent cannot delegate his authority to other person. This is also important. Agent has been delegated, okay, to perform the instructions given by the principal. So at the same time, he cannot delegate his authority to other person. And this is based on the maxim delegatus non potest delegare, means a delegate cannot delegate. That's why agent cannot delegate other person to perform his authority. Okay, so this is the general rule. However, there are few exceptions to this rule. First, when the principal approve the delegations of authority. When the principal give consent for the agent to appoint other sub-agent. Okay, this is based on the case of De Besche against Ops. In this case, okay, principal appointed agent in China to sell a ship at certain price. But the agent was unable to sell the ship, and so he sought the principal's approval to appoint sub-agent to sell the ship in Japan. Although the maxim delegatus non potest delegare applies, but there was no breach because in this case there was express consent given by the principal in order for the agent in China to appoint other sub-agent. And then where it is presumed from the conduct of the parties, agent will have power. So based on conduct, based on custom that permits delegations, based on the nature of the agency, okay, that the delegation is necessary, and then based on necessity or unforeseen emergency, for example, illness of agent, so agent is required to appoint sub-agent, okay, where the act to be done is purely ministerial or clerical and does not involve exercise of discretion. Exercise of discretion meaning that in the case, in determining the price of the house, for example, okay, to sell the goods, so it requires exercise of discretion, judgment of the agent. So if that is the case, then agent cannot appoint sub-agent. If there is only purely ministerial, maksudnya based on clerical works only, then agent may appoint sub-agent. Okay, so that's all. 10 main duties of agent towards his principal. So later we continue with the duties of principal.